Hello everyone and welcome back to the channel. We had an interesting ruling out of a U.S. District Court this week, and that is that a judge found, under Bruin, that banning someone from owning a gun for the rest of their lives over a drunk driving conviction is unconstitutional. That's not to say that drunk driving isn't terrible, because it is, or that guns and alcohol mix, because they don't. But it's certainly an interesting turn of events under Bruin. The case was brought by Edward A. Williams, who was convicted for drunk driving about 20 years ago. He was sentenced to 90 days to 2 years, which he was allowed to serve at home due to a medical issue. In 2017, he filed suit to try and get his rights back, saying it was unconstitutional for him to lose his rights over a nonviolent misdemeanor conviction. He lost. I am assuming at this point that he is sober, or else that would be really ballsy to try to take this back to court. Recently, he joined with Firearms Policy Coalition and tried again under Bruin, which also leads me to believe that he is sober now because I don't think that they would be putting their butts on the line otherwise. On Tuesday, U.S. District Court Judge John Milton Young ruled in his favor. He wrote, "In no way does the court dispute the dangerousness of drunk driving or of combining firearm use and alcohol consumption, and it acknowledges that plaintiff's offenses were serious and his conduct during his convictions in 2004 and 2005 dangerous. However, that legislatures have historically labeled certain groups and conduct dangerous for the purposes of disarmament does not, in and of itself, create a historical analog to the present-day prohibition on firearm possession by those convicted of DUIs." The Range Court had rejected the argument that status-based restrictions on dangerous groups identified as such by the legislature would constitute an appropriate analogy to Section 922 G1 today, noting that legislatures are not empowered to eviscerate the general right to publicly carry arms for self-defense with overbroad categorizations. Historical regulations on persons deemed dangerous do not present a sufficient historical analog without showing that the regulated conduct itself is analogous to plaintiffs. The judge in that Colorado case video that I did the other day should probably check this out. Anyways, similarly, the court finds the government's argument that Section 922 G1 can be appropriately applied to plaintiff because of historical regulations on the possession of a firearm by a presently intoxicated person unavailing. The government points to several regulations permitting the disarmament of drunk or intoxicated persons. None of these regulations allude to disarmament lasting beyond the individual's state of intoxication, and none provided for permanent disarmament as Section 922 G1 does. Certainly, this court agrees that using a firearm while intoxicated is dangerous, but historical regulations which momentarily disarmed certain individuals for temporary mental incapacity cannot be considered similar to the sanction of permanent disarmament for past DUI convictions. As noted in Range, government confiscation of the instruments of crime, including to prevent an imminent crime, differs from a status-based lifetime ban on firearm possession. As stated in Bruin, the court must consider the how and why behind Second Amendment restrictions to determine whether the modern articulation is relevantly similar to its proposed historical analog. The language in the regulations offered by the government suggests an interest in protecting the public from an inevitable danger caused by allowing a presently intoxicated person to use a firearm. Section 922 G1's prohibition on firearm possession for those convicted of a DUI cannot, without significant speculation by the court, be considered as having a substantially similar purpose. In the end, Judge Young concluded, "The government has not carried its burden in proving that the United States tradition of firearm regulation supports stripping an individual of their right to possess a firearm because they had previously driven while intoxicated. The application of Section 922 G1 to plaintiff, therefore, constitutes a violation of his Second Amendment rights, and the court finds that plaintiff is entitled to the requested relief." I am sure that the government is going to be appealing this one, but it's going to be an interesting and fun one to watch for all kinds of reasons. Feels a little bit like we got some Bruin Wild West going on here. And I'm sure that the legacy media will paint it as such, like in the worst possible way. So I will be keeping track of any developments on this case. You guys know all the stuff for the algorithm. I don't have to tell you every time. You know the drill. And as always, thanks for tuning in and happy shooting.